Joining us now on the Oakland County Megacast is Susan Strunk. She is an attorney and a counselor at Monaghan PC. Susan, thanks for joining us today.
Thank you so much for having me, Tyler.
Appreciate having you on. So we've had some recent discussions with financial advisors and other financial experts about a number of topics, especially in today's economy, and then also just seeing in recent weeks, especially here in Oakland County, the impact of some tragic deaths of people that were in the community. And that brings up the topic of estate planning, which for so many is something that they focus on maybe later on in life or after they have kids. But in a general sense, Susan, who should be focusing on estate planning and when should that focus begin?
Yeah, you hit the nail on the head, Tyler. I would say as early as the age of 18, you could start to set up some documents for yourself. Something that maybe I would recommend for an 18-year-old would be to get some powers of attorney in place. Those would be financial powers of attorney, healthcare powers of attorney. These are documents that if something were to happen to you during your lifetime and you were seen unable to make medical or financial decisions for yourself, you would assign a patient advocate or an attorney in fact to make those decisions for you, and they would follow the instructions that you set forth in your document. I think a common misconception with powers of attorney are that there's any sort of effect after you pass. That's not the case. They are only effective while you're living. So these kind of things come into play when we least expect them, when you're in a car crash and you become into a coma or something of that matter. So it sort of helps your family out in a very difficult time of their life and your life, and it doesn't leave people scattering to try to figure out what you might have wanted. A lot of clients say, pull the plug, not pull the plug. We put it in much more precise terms, but those are sort of the types of decisions that you make long before that moment of need happens. And that's sort of something that I would recommend to maybe a young person that's thinking, I don't really have much, and that's another thing. I think there's a myth that you have to have a lot of money to go to see someone or get some estate planning documents set in place. It's not the case. When you pass, you can't take it with you when you go. So one of two things will happen. You will have either set up during your lifetime either a will or a trust, which when you pass away, the terms of those documents go into place and you either have someone, a personal representative or a trustee, carry out your wishes. If you haven't prepared those documents, your things are subject to the law of intestate succession. And for some people, that actually might be all right because the legislator has come up with a set of statutes that says if you die, your property goes to this person. And it sort of goes down. It's something called the table of consanguinity. But in today's modern world, where we are maybe getting further and further away from it making sense for your house and your money and your stocks to go to a next of kin, that's also another reason why it makes sense to get a plan. Are you not married? Maybe it makes sense to be in a domestic relationship, or maybe it's a blended family. We're seeing that a lot with older individuals as they near end of life. And I would just really recommend people of blended families to have their documents set forth. Come meet with me or anyone and have those documents written, have them signed, have it very clear what happened at the end, because we're seeing a lot now. We have adult children from, marriages sort of coming forth, and, sort of the oldest flaw in the book as far as greed. And it also stems from very, complicated familial issues that sometimes come out decades and decades later. Mom left me out, or something, and sort of, you see this rogue child maybe wreak havoc on the estate or really cause people a lot of despair. So, and also sort of speaking in another way of who should have the estate plan, people with young children. If you pass, who determines who your legal guardian is? A judge. A judge will decide that, unless you have set forth in a will who you want to be the legal guardian of your children. That's also another reason people with minor children sometimes are interested in a revocable living trust. And perhaps we could talk about trusts on another time, that we could maybe talk about the ins and outs of trusts. But one of the really good things about trusts are, say you have a 5-year-old. Well, if something were to happen to you, the money set aside for that 5-year-old would be under the custodian of whoever you set forth in a will or something in that matter. But when they turn 18, if you only had a will, that money hits their hand. I would say 99.9% of my clients are not comfortable with that. And especially considering the fact that if that's happening, the reality may be that 18-year-old has lost both parents. So we're not sure what sort of path the child might go down out of despair, or they might, all sorts of things can happen. And we sort of, when we're doing estate planning, we're planning for those unknowns. So we're planning for the worst case scenario. But with a trust, you can dictate what age the child would receive money. For example, when they're 18, maybe they get 20% of the money that you have set aside. When they're 25, they get half. And when they're 30, they would get 100%. Those are some common distribution ages. So that's really a great benefit of having a trust. And then, a problem with a trust, a lot of times people don't fund it. It is a little more legwork. Properly retitling certain assets into the trust. The trust is a big, maybe, a pot or a pitcher of water. And if you just leave it empty, you just have this great vessel with none of your assets in it, it's useless. So my clients, we don't have that issue, because I really do help and make sure that all of their assets are properly funded into that trust. But I can't know if they will die with the $1 million lottery ticket in their hands. That's always the joke that we use is, sometimes things get left out. And in that case, if there was something left out of a trust, you're going to be, your estate will be subject to probate. And I'm approaching again another topic that could be easily another 15-minute session, but and going into probate is not the worst thing. Basically, it's a judge overseeing the distribution of your estate, and it can be as formal or informal as the beneficiaries and the personal representatives see fit. You could have, celebrities you hear that go through probate court, but you can also have, a single widow that just had a home that, she had not put into a trust, or she didn't transfer via a deed or something of that matter. So we're seeing all sorts of estates that can be in probate. And, there are a couple benefits of probate. Some of them are, there's sort of a finite start and end date. So if there are some creditors, there's a bunch of procedures that occur, and once those procedures and once certain deadlines are met, creditors are barred from making further claims of the estate. So it does give people peace of mind. So maybe for larger estates, and if there's a lot of unknown creditors or known creditors, it sort of does give beneficiaries and personal representatives that peace of mind. But some of the negatives are it takes many months. There's statutory requirement of how long the probate has to be open. There are many documents that need to be filled out. There's just a lot of more paperwork involved, where I would say 9 times out of 10, the costs incurred and the extra year of having to work with an attorney or try to do it yourself is not worth the cost that you as you're sort of looking at your estate, if you just make those decisions now, do that planning now, and have a system set in place, it's a lot more effective.
So, Susan, where should somebody start as they're preparing to go through the process of writing a will or of crafting a will with an attorney or a counselor? What should they have prepared? What are some key points that they should be preparing before they start that conversation or as they are preparing and writing their will, even if it's something like Michigan's statutory will?
Right. Yeah, Michigan statutory will. I'm really glad you brought that up. That is a free option for someone if the cost is prohibitive, where you can accomplish those goals of deciding who you want for your guardian. Some of the choices that you need to be thinking about is who are you going to task with administering your estate when you pass. Traditionally, if you have a spouse, they're usually the first choice. Oftentimes we see siblings or children that are adults would be choices, cousins, stuff like that. And I think that that discussion needs to happen before you draft your will. I think you need to check in with that person and ask them if they think at this time that they would be up to that task when and if it occurs. And you have to have a few backups in mind if someone's unwilling or unable to act. And usually I suggest clients have at least about 3 people in mind for that role. And then, of course, the obvious, I suppose, of who's going to get the money, who's going to get the engagement ring, who's going to get the car, who's going to get the home, all of those sorts of things. And typically, when you meet with an attorney, they will probably have some sort of questionnaire that they have drafted. And I find it effective to have clients fill out the questionnaire. And then we come and we have the discussion and we go over the answers. And then at that point is when I can really tailor my advice and say, I'm not sure about this person's age or, this person's financial acumen. And maybe I would select different individuals, or maybe I would select different distribution tables. That's sort of where we have that discussion of what you want versus what I would recommend, and we can come out with an excellent plan that is ironclad.
A little bit of work now, a little bit of stress maybe now can do a lot of wonders for those that may be dealing with your finances, your assets, and what happens with your life after your life later on. So, Susan, we appreciate your time. Anything else that would be important for our audience to consider in regards to estate planning today before we let you go?
I would just mention really quick that I have been using Ladybird Deeds a lot for individuals where maybe their home is their largest asset. And some of the benefits of that are if, for example, you would like to leave your home to a child, an adult child, you can draft something. It's called an enhanced life estate deed. And Michigan and Florida are the only states that allow for these types of deeds. You can draft a deed that says, it gives you so much control over your property, unlike a typical quitclaim deed or a warranty deed, where if I draft that deed and I put my child on it, they become the part owner of my property as soon as I go and record it. So that is a problem as far as you don't know if your children will have a creditor in the future. And then when you want to go sell that property, let's say you and your child have a disagreement at some point, they have to sign the deed to allow you to sell your property. And most people are not comfortable with that. So the Ladybird deed is something that says you have all of this control while you're living. And if you don't sell or mortgage or reconvey the property before you pass, on the moment of your death, they would receive it. So there's a whole host of benefits to that. There's also some other step up in tax basis benefits. And I guess I would just advise people, if your home is one of your largest assets and you haven't given consideration of what's going to happen to it when you pass, I would recommend that you contact an attorney and ask them whether they think a Ladybird deed is right for you.
Susan, appreciate your time. Thank you so much for joining us.
Thank you, Tyler.